Okay, this week's lesson is on Chapter 7, the Courts and the Quest for Justice. So our learning outcomes for this week are we're going to define jurisdiction and talk about subject matter jurisdiction and geographic jurisdiction, what the differences are. We'll explain the differences between the trial and the appellate courts. We'll outline the several levels of courts in the state court system and the same thing in the federal system. We'll explain briefly how a case is brought to the Supreme Court, and there's also a video on that also. We'll listen to describe the members of the courtroom work group. We'll list the different names given to the public prosecutors and the general powers that they have, and talk about the responsibilities of defense attorneys. So what are some of the functions of the courts? Good question. Glad you asked. There's the due process function. That's to make sure that the constitutional rights of each individual are protected. There's the crime control function. That's to make sure that those who are arrested are properly punished for their crimes, if appropriate. There's a rehabilitation function. That function is that people that get put in prison shouldn't be their career being in prison. They should be rehabilitated and come back to be functioning members of society. Sometimes they need treatment, such as in drug treatment, alcohol treatment, stuff like that. That's part of the rehabilitation function. And the bureaucratic function, which is taking care of the tasks of processing court cases. There's a whole system as they go through. We'll talk about more of that in the chapter we talked about the trial. So let's talk about geographic and subject matter jurisdiction. The two types. So jurisdiction, by its very definition, is called the ability to hear court cases and decide cases. And actually, the word jurisdiction talks about the ability to enforce law. But in this case, with the courts, it's the authority to hear court cases. So, how do we determine what authorities the court have? Well, there's two types. There's geographical and subject matter. So, geographic is a geographic boundary, such as Los Angeles County. Each county has a superior court system in California, and in Los Angeles, we have the Los Angeles County court system. We also have international courts, the World Court, things like that. Now, the court has authority in each country, but may or may not have authority in outside of their country. For criminal law purposes, you need to focus on what happens within the borders of the United States. If you get arrested, say, in Mexico, do you have the same rights as you have in the United States? Not at all. Then we have subject matter courts, and those are limited in jurisdiction. We'll talk about that in the next slide. So we'll talk about the difference between the trial courts and the appellate courts. Go back here just for a second. The appellate courts never hear original cases. In other words, you can't go straight to an appeal court, and not everybody is guaranteed an appeal. The appeal is based again on whether or not there was some mistake made in the trial, such as evidence was excluded, evidence was allowed in, evidence was not ruled upon correctly, the jury was given improper instructions on how to take care of, how to interpret evidence, they were given improper instructions on how they can decide the case. When we get to the trial phase, we're going to talk about jury instructions, and those are very important because it tells the jury exactly how they can interpret whatever evidence they saw and heard. So we have a dual court system in the United States. We have both the state courts, you like that little animation, and state courts and federal courts, and they both have limited jurisdiction. Now, federal courts enforce federal statutes. In other words, immigration type laws, some drug statutes are federal, things like that. Interstate transportation of stolen property, kidnapping, those are all federal cases. State courts back to federal here for a second. State courts enforce state statutes. In other words, in California, if you get arrested for, say, a murder, which is a 187 of the Penal Code, you're tried here in state's courts. However, if you murder a federal officer, such as an FBI agent, that's a federal crime, so they can try you in federal courts. So there's the jurisdictional differences. And sometimes they have concurrent jurisdiction. Like I just said, if you murder a federal officer in California, you've got the California murder, and you've also got the federal murder. A lot of drug cases are cross-jurisdictional, and sometimes they'll take cases to the federal courts because the federal courts have different rules than state courts and have a better chance of getting convictions if you're a prosecutor, and the penalties are lots differ. Sales of drugs, for instance, if you sell drugs and it's a state offense, you're likely to get a very light sentence to start with in the state. Federal, they have mandatory sentencing laws. You can go up to jail for up to 10 years for selling drugs if they try you on a federal jurisdiction. They'll look at what's the best interest of the case. The dual court system, again, in the upper courts, the United States, in the upper courts, you have your U.S. district courts. So if you have a federal case, that's the first case it goes is the district courts. Then it goes up through the appeal process of the district courts, and eventually could reach the Supreme Court. The video slideshow I have in a couple slides from now tells more about that. State courts, you have local trial courts in California. That's mainly the superior courts in the counties. And then you also have state courts of appeal to appeal courts case rulings on state cases. And you also have state courts of appeal up to the state Supreme Court, and that's the highest court in the state, and it rules on states' rights issue. So an example would be we passed a law a while back on gay marriage. It said that in California the voters decided that gay marriage was to be illegal. In other words, it had to be a marriage between a man and a woman. So originally, because it was a voter passed, it had to go through the California State Supreme Court. It eventually made it to the United States Supreme Court, where the Supreme Court threw the case out on a technical issue. Basically, the person bringing the case to the court did not have jurisdiction to bring jurisdiction. And that's one of the parts of the ethical question we have for our discussion this week. Is it was Kamala Harris's job to defend the voters of the state of California, to present a case to the Supreme Court, and she refused to do so on moral grounds because she did not believe in the statute that was passed, even though it was passed by the consensus model. The people of the state of California believe that a marriage should be between a man and a woman, but Kamala Harris personally did not believe that, so she refused to do her job. So our question is it ethical to refuse to do your job if it's on high moral ground? And at what point does it become insubordination, basically? So here are the levels of the state Supreme Court, the state court. We used to have justices of the peace courts. Now this lesson plan, of course, is written for all of the United States. So some United States still have justice courts. In California, we do not have justice courts anymore, and we don't have municipal courts. We only have superior courts, which is that purple box in the middle there. So superior courts are what we have in California. And if you get a case heard in Superior Court and you're found guilty and you feel there was some kind of mistake, like I said, you can appeal that. You can appeal up to the appellate courts and then up to the state Supreme Court. Federal court system. Sorry. Oh, by the way, that's one of the justices of the court, Sotomayor. And so the Supreme Court can hear cases, but do they hear every single case that gets brought to them? Not at all. Less than 0.5% of all cases in the United States are heard by the Supreme Court. And they have to concern a substantial federal question or a constitutional question. So what's a constitutional question? A constitutional question will be something like, was the search legal, as we talked about in just the previous chapter here? Was the search legal? And again, it's not as set in stone as you might think. You look at the Fourth Amendment, it's only a few sentences, it seems pretty clear, like we learned in the last module. However, it's not. It's open to interpretation, it's open to changes. So they'll look at that. Or there's a substantial federal question, such as the Affordable Health Care Act. A few years ago, some people call it Obamacare. The Affordable Health Care Act passed, and because it mandated a behavior by the entire United States citizenry, there was a substantial federal question there, and so cases were brought before the Supreme Court asking, whether it is okay for the federal government to require the people to perform a certain behavior. In this case, it was to buy private health insurance. It wasn't government health insurance; it was private health insurance. So they're requiring you to buy a private product. And was there a substantial federal question in that? Was there a public good question in that? And the court sided with the authors of the Affordable Care Act, saying yes, there was a substantial good to having people insured and a substantial benefit to society for that. And how they selected us through a writ of certiorari. The video talks really in depth about that, about the writ of certiorari and how they do that. But basically, what that means, it's a Latin term. What it means is give me the papers. So the court will say, give me the papers, which means give me the court record, and they'll look at it, and if 4 of the justices decide, hey, we should look at this, then they'll bring it to review. And just because they actually look at it initially doesn't mean they're actually going to make a ruling on it. They have to actually, after they look at it more in depth, they might say, nah, this is not the one we're going to look at. Again, the video in a couple of sections here talks more about that. And so the other thing about Supreme Court cases, a lot of people say, well, it's just that they believe, that it's just by luck that cases get to the Supreme Court. That's not actually true. The Supreme Court will pick a social issue, and they'll pick a case that they believe would have a substantial impact on the social issue. A good example is the Miranda case. It wasn't chosen at random. It was chosen specifically because of the way as you know, Miranda required the police officers to read your rights to remain silent and advise you have the right to have an attorney prior to being questioned by the police. Now, you always had that right, but before the Miranda decision came down, again, you weren't told by the police that you had that. So they believed that there was a substantial need for the police to give more power back to the people and take a little less power from the government. And so they looked for a case. Miranda fit the case. They brought Miranda up through the courts, and they ruled on it that yes, the police now have to read the rights. So the courts make policy in 2 ways. First way is through judicial review. They review the case. They say, hey, is this a good case? Is this a bad case? Were there mistakes made? Something like that. The other way they do it is the interpretation of the law. Again, search and seizure. That's a great one. Search and seizure changes so often that you really need to stay on top of it if you get into this business, either as a law enforcement officer or a court person, part of the courtroom group, which we'll talk about in a few minutes. You need to stay on top of that law. Here's just a quick thinking point if you want to think about it. The Supreme Court ruled that back in 2012, Arizona basically said that the federal government's not doing their job, so we're going to do the federal government's job for them, and that's enforcing immigration laws. The United States Supreme Court said, you know what? It's a federal jurisdictional matter. States do not have jurisdiction. We talked about this in an earlier chapter. States do not have jurisdiction to enforce federal laws. As a state of California police officer, I could not enforce immigration laws. I could refer the case to the appropriate authority, but I could not arrest somebody, take somebody into custody for being illegal alien or other matters like that. So anyway, they struck down the Arizona's law because of the ruling that it violated Arizona's jurisdiction. Now they still let them refer the case, basically, as long as there's suspicion, reasonable suspicion. We talked about probable cause and reasonable suspicion in an earlier module. So what gives you reasonable suspicion? In this case, are they stopping Canadians? Because it's really easy to pick out a Canadian, right? Yeah, wrong. They're probably stopping people of color, most likely it impacts people of color a lot more than it'll impact people that are Caucasian. So, does that open a case for racial profiling? Do you disagree? Do you agree? Just think about it. There's no test on this, just a discussion point. So the judge's role. They're part of the workroom group, the judge's role. Lots of rules. They're a negotiator. Sometimes they negotiate plea deals, court dates, stuff like that between the prosecutor and defense attorney. They act as a referee. They also make sure the trial goes by the way it's supposed to. There's a set structure for a trial, and if it's not done right, that could be a question of law that could be brought up in an appeal. So they make sure that the trial goes correctly. They also a teacher. They have to explain to the jury, and a lot of times I've seen them explain the law to the attorneys, which is kind of funny to watch, actually. You think attorneys are like anybody, like doctors. They get a specialty. So if you're a wills and trust lawyer and you decide to defend a buddy of yours in criminal court, you're probably going to be a fish out of water. And so I've seen the judges have to explain to attorneys in court, sorry, you got the law wrong. You need to go back to study the books and get a specialist in this field. Law, like anything else, has specialties. And an administrator. They're responsible for the day-to-day operations of the court. Federal court judges are appointed by the president and confirmed by the Senate. Every once in a while, confirmation will get derailed on political grounds. There's something going on, and say a Democratic president appoints a person to the federal court, and the Democrats don't like it, so they'll block it, and same thing goes the other way around. State court judges. Most of them are appointed, some are elected. How you get appointed are that a vacancy occurs, and it's usually done on purpose. They'll retire in the middle of their term. They run in terms like presidents do. They run in terms. They'll retire in the middle of their term, and then that allows the governor to appoint somebody to come into the position. And once they're in that position, they do run for re-election, but to be honest, not a lot of people vote on judges. I don't know about you, unless I know the judge, or I've been before the judge, or I've done some really good research on that judge, or the judge has been in the news for doing something wrong. Most of the time, a lot of folks don't vote on the judges. I mean, think about yourself personally. When was the last time you voted for a judge? There we go. So which each one of them do. The judge, I already explained the judge's role. Prosecutors, they're the ones that prosecute the case for the people of the state in California, for the state of California. They present the case to the jury seeking to get a conviction. Defense attorneys provide defenses for the defendant. There's a whole list of defenses we talked about earlier. And they'll also make sure that they'll try to get evidence excluded and testimony excluded, so that that doesn't go bad for their clients, and to make sure their clients' rights were protected. They weren't questioned without proper Miranda. They weren't searched illegally, stuff like that. The bailiff, they're like the police officer of the courtroom. They're usually uniformed deputies at the county level in California. It's uniformed deputies from each county. At the state level, such as the state Supreme Court, it's uniformed CHP officers. A lot of people don't know that, but that's CHP's jurisdiction on the state level. They're the bailiffs there. I actually served as a bailiff in one of the courts in the Court of Appeals. It was filling the detail for somebody that called in sick and they needed a body, so I threw my uniform on and went down there and acted as a bailiff for the day. The clerks of the court, they're the ones that process all the paperwork that comes through. If some evidence gets presented, if the judge makes a ruling, the clerk of the court makes sure that they put this stuff into the computer, into the record. The court reporters is that little person that sits right in front of the jury box, in front of the judge, and they record all the testimony. So they record what the judge says, they record what the defense attorneys say, they record what the prosecutors say, and they record what the witnesses say. court reporters used to really dislike me because, as you notice, I talk a little bit fast, and so sometimes when I get going in a fury there, they need me to slow down so they can actually type everything they need to know in there. Alright, the courtroom work group. They each have the specialized tasks. I just talked about that. Some judges are more tough on crime. Some judges say, hey, you know what, let the process go the way it wants to go. I already talked about the prosecution. They prosecute the criminal cases on the behalf of the public, in the name of the people. So we're going to list the different names given to public prosecutors and indicate the general power that they have. So at the federal level, they're called U.S. attorneys. At the state level, state's attorneys, state's prosecutors. In California, we call them district attorneys or city attorneys. We don't have county attorneys. We have district attorneys and city attorneys in California. They all have the same rule. They prosecute cases. So the prosecutors, what kind of authority do they have? Well, they have a lot of authority to decide what goes on. They decide whether a suspect will be charged with a crime. They decide whether or not there's public good in doing it, whether there's enough evidence. They also decide the level of charges. In other words, they're going to charge this guy with murder, or they're going to charge him with first degree, second degree, vehicular homicide. And they'll talk about if and when to stop the prosecution. In other words, hey, this thing's gone along far enough, maybe you got a mistrial, and they have the ability to try him again. They'll say, nah, we should stop. In the interest of justice, we shouldn't try this case anymore. In most jurisdictions, the prosecution's decision whether or not to try a case is not reviewable. In other words, just because you're the victim of a crime, and it could be a heinous crime like a rape or something like that. And I know of rapes. As a matter of fact, I know very close to victims of a rape that they decided not to try the case because they felt that there was not enough evidence to get a conviction. And these folks get reelected on their conviction rate, and so if they can't get a conviction, they're not going to bring it to prosecution. But again, you can be influenced by community pressures. I love talking about the George Zimmerman case. The original prosecutor in that case decided there was not enough evidence. George Zimmerman, by the way, was the guy that killed Trayvon Martin, and I'm not going to argue the facts of the case. I'm just going to argue the decision of talk about the decision of the prosecutors. The prosecutors originally looked at the case and said there is not enough evidence to convict Mr. Zimmerman of this crime because of the way Florida's laws are structured. They felt that he had a very good defense, and that they weren't going to prosecute the crime. But the community pressure came out and said, oh my God, this is a heinous case. There's all kinds of political issues behind it, really similar to what's going on right now in Ferguson. And there's a lot of political issues behind it, and because of that, they brought it to a different prosecutor. That different prosecutor looked at the case and said, because of the public pressure, we're going to try this case. And you all know what happened. The first prosecutor ended up being right. The jury unanimously said that there was not enough evidence to convict Mr. Zimmerman of murder. Again, I'm not going to argue the facts of the case, just the decision, just talk about the decision of the prosecutor. And that was the one case I just talked about. There's lots of other cases. There's tons of other cases out there where the public outcry has led to prosecution. This is a slide on the courtroom work group. These slides are also in the available to you. I gave you the slides without the narrative, so you can look at that if you want to look at it even deeper. But there's all kinds of different functions in there. So the defense attorney, what's the defense attorney's job? The defense attorney's job is to ensure the government proves every point against the client beyond a reasonable doubt. We talked about we'll talk about the standard of proof in a few chapters here. The standard of proof is beyond a reasonable doubt. And we talked a little bit about that in an earlier chapter. But so they have to make sure that they have to ensure that the government proves its point. If the government doesn't prove its point, then the client gets not guilty. They also have no obligation I forgot to mention this, but actually we're going to talk about it in the next chapter when we talk about the trial. We have an adversarial system in the United States, whereas it's one side against the other. In other countries, that's not the truth. In England, they seek to find the truth. They don't want to know win or lose losses. They seek to find the truth. In our country, it's whether or not it's fair, we look for wins and losses. Great example was the O.J. Simpson trial from the 90s. O.J. Simpson, there was an overwhelming amount of evidence against O.J. Simpson to say that he murdered somebody, but there wasn't enough evidence to prove beyond a reasonable doubt, and the jury found him not guilty. However, in the civil trial, and we'll talk about that next chapter, in the civil trial, they did find that there was enough evidence, on the preponderance of evidence, that he committed the murder. So, one jury said not beyond a reasonable doubt, but at least there was enough evidence that they believed on a civil trial that he did do it. So they're not really concerned about the guilt or innocence, they're concerned about winning. Charlie Sheen, winning. Here are the responsibilities of the defense attorney, and keep these in mind because your discussion question later on in this chapter talks about these. Provide legal representation to criminal defendants, investigate the incident. Now, that's an excellent job if you want a job that's non-uniform. Be an investigator for the defense. A lot of private attorneys will hire private investigators. The public defender has an investigative arm, and they'll investigate and go back and talk to some of the witnesses. If you've ever seen the movie My Cousin Vinny, the defense attorney goes out and he does his own investigation where he talks to all the witnesses and gets information the prosecutor didn't know about. Their job is to communicate with the prosecutor on your behalf if you're the defendant, prepare your case for trial, submit motions for defense motions, which are motions such as you want to exclude evidence, maybe you thought the evidence was seized illegally or is too prejudicial to the jury. In other words, if you show a murder scene with a lot of blood, that may make the jury more apt to convict you, so they try to get that stuff out. Certain witnesses, you might not want to get a witness in there because you might not think that they're credible. Negotiate a sentence. Now, sometimes there's a plea bargaining function where they negotiate a sentence. And they also decide whether or not to appeal a guilty verdict, whether that's a question of fact, a question of law, not a question of fact. Again, a question of law that determines whether or not to appeal a guilty verdict. So there's two types of defense attorneys. Your private attorney, just from my experience, I'd say if you can afford one, hire a private attorney. If you can't afford one, you've got to take out loans, hire a private attorney. There's nothing against public defenders. Our next slide here. But they work for the government and they have a huge caseload, and most of them are very, very competent in what they do. I see them, I watch them all the time. However, if you hire a private attorney and they go to court, they're there on your behalf, and that's usually it. If you hire if the public defender gets appointed to you, the public defender will have hundreds of cases, and so you're one of a stack of cases, and so they may or may not have enough time to actually defend you to their best abilities. Attorney-client privilege. Basically, when you're talking to your attorney, it's privileged conversation. In other words, the attorney can't be called to testify. So say you're talking with your attorney and you tell the attorney, hey, yeah, I did kill my business partner. I didn't like the way he was doing things. That defense attorney cannot bring that up in court. It also, like I said, to criminal convictions. However, if you say, hey, you know what, as soon as you get me out of here, I'm going to go home and kill my wife, okay, that's a different story. Then the defense attorney has to let the court know that information so they can protect the wife. This is what I was just talking about. They're overloaded. This says 40 to 60. I've seen 100 cases, serious felonies in court. They do their best, but they're just overwhelmed.